Good afternoon, everyone, and welcome to the Vermont Law Review's Spring Symposium. I'm Pat Parenteau. I'm the faculty here at Vermont Law School. Been here for more years than I care to recount, but I'm still having fun. And we have for you today, as usual, with our Vermont Law Review Symposia, a terrific panel. And I'm going to introduce all four of our panels for the discussion this afternoon, and then I'm going to turn the program over to them, and I'll keep time. The process is for each of our distinguished speakers to have about 15 minutes to provide some opening comments on each of their topics. And then we will save, we hope, an hour or so for your questions. And I think you've been instructed on how you can post questions on Facebook or on the chat, and we'll try to get to as many of those questions as we can. I think you'll find the topics very engaging, might even be a little provocative from time to time, but that's what makes it fun. Let me start off by introducing Professor Jill Family, who is currently the visiting professor at the University of Baltimore Law School, but she's also the Commonwealth Professor of Law and Government at Widener Law Commonwealth and the director of the Law and Government Institute at Widener. Her topic is going to be unchecked executive power in immigration law during the Trump administration. Next, we'll hear from Hal Krent, professor of law at Chicago-Kent College of Law. He'll be talking about the independence of administrative law judges due to the removal jurisprudence of the Supreme Court. Then we'll hear from my colleague, Richard Sala, who is the interim director of our Academic Success Program and also assistant professor of law on the faculty here at Vermont Law School. And then we're going to hear from John Yoo, the Emanuel S. Heller Professor of Law at the University of California at Berkeley, talking about the war powers in the Trump years and whether Congress can stop a president from withdrawing troops rather than sending them to war. So without further ado, let me turn it over to Jill and let her begin our conversation.
Good afternoon, everyone. Thank you so much for inviting me to be a part of this wonderful conversation. And I am here this afternoon to talk to you about something called the invisible wall. Now, that may sound like something out of a mystery novel, but it's not. It is a Trump-era policy that effectively limited the amount of immigration to the United States, despite that there was no changes in the immigration statutes. So what I'm going to talk about today is the invisible wall, tell you a little bit more about what it is, talk about how, in contrast to prior administrations, this was really a different way to look at the president's power over immigration law. I'll talk a little bit about how the Trump administration built the invisible wall. And then finally, I'll wrap up with some lessons for administrative law based on this experience. So as I said, the invisible wall is a Trump administration phenomenon, and it's actually pre-COVID. So there were a lot of immigration restrictions that were implemented in response to the pandemic. And what I'm talking about this afternoon all happened before the pandemic. So these are not restrictions that were put into place because of the pandemic. And as I mentioned, the Trump administration lowered the amount of lawful immigration to the United States in the absence of statutory change. So the immigration statute stayed the same, but the number of immigrants lawfully admitted dropped under the Trump administration. And the Trump administration accomplished this through a series of bureaucratic maneuvers, which the administration itself called, quote unquote, workarounds of the statute. Now, all presidents have power over immigration policy. And in fact, immigration law is an area where presidents have always had a lot of power. And presidents have always, through the enforcement of the immigration statutes, exercised discretion through administrative agencies. So immigration law always looks different from presidential administration to presidential administration. So the question is, what was different about this? What was different about President Trump's invisible wall? Well, the Trump administration seemed intent on making immigration as difficult as possible no matter whether its tactics complied with rule of law values. So the tactics that the administration used to build the invisible wall, which are different from the actual physical border wall, but more, as I mentioned, those obstacles, or you can think of it as sort of hoops and jumps that people would need to get through in order to achieve a legal status in the United States. And the tactics that the Trump administration used, they offended rule of law values because they were intended to make an end run around the statute. So the Trump administration often didn't like what the immigration statutes provided or allowed, and so the Trump administration worked to thwart those statutes. Additionally, the tactics that the Trump administration used were often opaque bureaucratic maneuvers that weren't well publicized or explained. In fact, President Trump publicly pronounced to be in favor of lawful immigration, but his centralized control over administrative agencies evidenced otherwise. So lawful immigration encompasses, when I use that term, I'm talking about individuals who are applying for an immigration benefit. So those individuals are applying for permission to come to the United States, either to work or to be with close family members. And the administration's efforts to thwart legal immigration went beyond efforts to prevent asylum seekers from accessing the border, and went beyond efforts to ban nationals of several Muslim majority countries from entering the United States. The Trump administration also worked to block employment-based immigration, so no area of immigration law went untouched. And the Trump administration leveraged its centralized control over USCIS to implement those bureaucratic maneuvers that I mentioned, such as increased procedural burdens in filing a benefit application, increases in what we call RFEs, or requests for evidence, where your application essentially comes back to you and tells you that you have to do more. Also, there were changes in sub-regulatory policy that made achieving legal immigration status more difficult. There was a decrease in engagement with regulated parties, and there was a de facto increase in the burden of proof. So it took more evidence, it took more to convince the Trump administration to issue or to approve a legal immigration status. Now, I've undertaken a scholarly case study of the invisible wall, and part of that scholarly endeavor is that in early 2020, I interviewed business immigration attorneys, and those interviews revealed a predominant belief that the Trump administration worked to subvert legal immigration to the United States. These attorneys believe that the Trump administration did not care whether the legal immigration system was dysfunctional. In fact, some said that they thought the dysfunctionality worked to achieve the Trump administration's goal of lowering the amount of immigration to the United States. When I asked these attorneys what the phrase invisible wall meant to them, almost every attorney expressed deep frustration. So here's a sample of some of the reactions. One attorney said, "It is death by 1,000 cuts." Another attorney said, "It is making practice a living hell." Another attorney said, "You can see the venom in it." Another one said, "No one meets the statutory requirements." Another said, "It is maximum pain to the most vulnerable." And another said, "I never imagined it would be this bad." So how did the Trump administration accomplish this? Well, in administrative law, there are both external and internal checks on agency behavior. External checks come from outside the agency, such as from Congress or the courts. And internal controls come from within the executive branch, such as agency quality control procedures and ombuds offices. But internal administrative law failed to prevent the construction of the invisible wall. So to the extent there were any internal executive branch checks that were supposed to protect against White House centralized control that violates rule of law principles, they failed. In fact, the case of the invisible wall represents a collapse of internal administrative law. Nothing stopped the Trump administration from implementing it. USCIS, which is the main immigration benefits agency, was not able to resist White House control. In fact, the administration pushed out an agency head that resisted White House control. The administration also co-opted the agency ombudsperson office to the point where the agency ombudsperson was arguing that the agency should do things that contradict the statute. In response to all of this, immigration attorneys turned to the courts, a form of external control, to attempt to bring immigration benefits adjudication back in line with the statute. And data that I collected for my case study revealed that the number of complaints filed against USCIS under the Trump administration increased drastically. So from 2016 to 2019, complaints filed against USCIS in federal district court were up almost 200% in one category and were up almost 250% in another. While courts were able to alleviate some aspects of the invisible wall, the courts could not reach others due to limitations on judicial review that are inherent in administrative law, and also because the number of complaints filed, even though up dramatically, were still relatively small compared to the number of applications of benefits adjudicated, or even compared to the number of applications denied. Also, we have to remember that judicial review always has a delayed effect, right? Even where challenges to the invisible wall were effective, the court action did not take effect until after the Trump policy, until after many of the Trump policies had been operative for some time, even years. So the invisible wall therefore illuminates unchecked executive power where internal control mechanisms failed and where external control was not wholly effective. So the invisible wall leaves us with a conundrum. To fill the gap of unchecked executive power, internal administrative law needs to be strengthened to provide protection when judicial review cannot. But can internal administrative law ever be strengthened enough to resist White House control that violates rule of law values? As the Trump administration showed, a president intent on bulldozing through existing internal agency controls can do so. It may be impossible to strengthen internal administrative law enough to fully carry this weight. So the lessons of the invisible wall reinforce the importance of courts as a check on agency behavior, but also emphasize that courts are not a perfect check. Internal administrative law needs to be strengthened, even if it may never be a perfect defense. So how can internal administrative law be improved? The key study shows that existing quality control mechanisms, at least within this one immigration agency, USCIS, were not enough. And while a higher quality control mechanism may not resolve all internal administrative law problems, it could help. The agencies are the first line of defense, as the agency will have early notice of abusive centralized control. Prioritizing rule of law values points to guiding principles for internal control reform at USCIS. So I've come up with some guiding principles for adjudication at USCIS. So these would mostly affect applications mostly would accept applications for immigration benefits. So I'm not talking about deportation hearings. I'm just talking about applications for immigration benefits. And my suggestion is that USCIS should adopt these principles through a notice and comment regulation. So the principles are as follows. USCIS's adjudicatory standards, procedures, and interpretations of law should be formulated and applied to promote values of clarity, predictability, timeliness, fidelity to existing law, and equal treatment. USCIS's adjudicatory standards, procedures, and interpretations of law should be formulated with an eye to increase the protection of human rights. USCIS's exercises of discretion should promote clarity, predictability, equal treatment, and human rights. The formulation of USCIS policies should be open and transparent, with clear policy rationales adopted. And finally, USCIS must insist on fidelity to its statutory mission and competence in its operations. These principles are all in line with rule of law values. Internal administrative law can help encourage adherence to these values. For example, USCIS could self-police to make sure it is complying with these guiding principles. That self-policing, however, will only be effective if the president allows it to be effective. So while these guiding principles admittedly may not be able to provide 100% effective defense, they would serve as an additional line of defense, and perhaps most importantly, would highlight the actions of a president willing to act against the values encoded in these principles. Thank you.
And now we're going to hear from Hal Krent. Go ahead, Hal.
Great. I'm just going to get the PowerPoint up if I can see it. Well, I'll tell you what. As you predicted, the PowerPoint has disappeared. So I will just give the talk without the PowerPoint. And thank you again to Vermont for hosting this symposium. I want to talk about the executive power as has been seen by the Roberts Court, as it's been further pushed by the Trump administration. Under Article 2, there's really only two formal ways in which the president can control this vast bureaucracy in the executive branch, and that is through the appointment and through the removal authority. And I want to welcome Beth McCormick into the ranks of the deans. I suffered there for almost 20 years, and I can tell you that in terms of trying to control the school, appointment is important, and so is removal, except you have no removal authority over the faculty. And so that, of course, undermines dramatically the power of the dean, and the same thing is true, of course, with presidents. And so for a mixture of formal and functional reasons, the Supreme Court has been pushing greater control for the president. I thank you to Emily, who has just been able to regain the PowerPoint. And what I think is important for this is if you look at three recent Supreme Court decisions, they have strengthened the president's authority both over appointment and removal, and that has imperiled the independence of administrative law judges. And I believe that, well, we'll go to those three decisions. I'll tell you why I believe that ALJs are imperiled, and then I'll try to give a brief defense for why ALJs should become independent. Just as Professor Family was discussing what happened to the immigration agency under the President Trump, it's important to have some kind of reservoir of independence in pockets within the executive branch to ensure more of a lack of partisanship, and particularly in terms of adjudicating facts against agency. So the first case to look at is the Free Enterprise Fund case, which said that 2 layers of insulation from the presidential control was unconstitutional. In other words, if you're an inferior officer, it doesn't matter if you're an officer in an independent agency, you have to be removable at will, because otherwise there'd be 2 layers of protection attenuating the ability of the president to remove somebody. So it's okay at times for Congress to say that a superior officer, the head of an agency, can be independent, unlike the EPA, which you're familiar with. But if the agency is quasi-independent, such as the SEC or the NLRB or FTC, then it's important that all inferior officers be subject to their at-will removal authority to ensure that there's not 2 steps in link between the president and not. And with respect to ALJs who work for independent agencies, they are, of course, then in the firing line, as was noted by the Supreme Court, though the Supreme Court, in a footnote, specifically decided not to decide about the status of ALJs. But they're also in the target because any kind of discipline against ALJs will be adjudicated by another independent agency, the Merit Systems Protection Board, and their heads are protected from at-will removal authority. The second decision is the Lucia decision, and the Lucia decision held that ALJs, for the first time in history, should be considered inferior officers because of their power to shape a case, to make decisions in an adjudication, and therefore their independence in terms of appointment, again, one of the critical control mechanisms, was removed. And instead of being appointed by a merit system, they're now appointed by the agency head themselves. So these two decisions, and now we have a third. Next slide, please. We have the third Supreme Court decision, which is the most recent, Sala Law, which the court recently held that the single member structure of the Consumer Financial Protection Bureau was unconstitutional. Why? We have, as I mentioned, the NLRB, the FTC, we have the SEC, but nonetheless, the court said that having one individual as a head of an agency just accumulated too much power in that individual. Didn't have to share power, didn't have to come to consensus, and so because of that, the president had to have the plenary removal authority over that official. In reaching that decision, the court looked to history and suggested that in almost all occasions, the Congress has not vested one individual with sort of independence from the president's removal authority. Again, there's multi-member commissions for the most part. Also looked at the importance of accountability. And just as in the Free Enterprise Fund, the court held that under our Constitution, the president must be accountable. And just like the dean has to be accountable, the president has to be. And the only way really to do it is to make sure that the voters can trace acts of administrative heads and acts of administrative agents to the president come election day. So this kind of symbolic link is critical for enhancing accountability and making sure that individuals can understand what the president is doing. There's some transparency and therefore accountability come election day. So as a consequence of these three decisions, there is again a big target on the back of administrative law judges if they work in independent agencies, and also if they work in Social Security Administration. They employ the most ALJs in the entire system by far, and because there's only a single head of that agency, all ALJs, independence within that agency is now imperiled as well. This is not just a theoretical concern I have. 2 days ago, the DC Circuit ducked this constitutional issue, but one judge, Judge Rao, decided that to reach the issue, and held that ALJs, for many reasons, cannot be independent, and therefore she would have ruled that this entire structure is unconstitutional. So what I'd like to do now in my remaining minutes is say, despite these three decisions and despite Judge Rao's recent decision, I want to take a plunge and suggest that there are good reasons, even within the scheme of the unitary executive set up by the Supreme Court, that we can carve out administrative duties exercised by administrative law judges. And I will turn to history for part of it. I will look to the importance of presidential accountability, as Chief Justice Roberts discussed in Sala Law, and I'll look to the nature of the ALJ duties themselves. So with next page, first look to history, and something which is not been thought about for much time is that there was actually little in the way of unilateral or unitary control of the adjudicative function from the outset of our nation. Now, there are not that many examples, and maybe there are more, but I found two relatively soon. Congress delegated the determination of Revolutionary War pension claims to judges subject to review by the Secretary of War. And so Congress did this, and nobody objected to the fact that judges, independent judges, Article III judges, played a role in deciding claims. There was a complaint that Congress should not have given these judges non-Article III duties, but there was no complaint that judges shouldn't have this adjudicative role. They, of course, were independent or insulated from the president's removal authority. Similarly, again, something that's not well remembered, in the Patent Act of 1793, Congress removed the power to determine patents away from the president's cabinet and instead delegated that responsibility into 3 arbitrators. 2 were chosen by the private parties themselves. Again, individuals outside the president's control played the role then in adjudicating the legitimacy of a patent in the early days. So these are 2 principal examples that historically, somehow adjudication has been viewed as quasi-independent, if you will, semi-independent of the president's control. And of course, next page, please. And of course, if you look to the Administrative Procedure Act itself, many of you are familiar with that. We've had a 75-year history of independence under the Administrative Procedure Act. And it's helpful just to think briefly about what lay behind enactment of the APA. The ABA report said it's not easy to maintain judicial independence or high standard of judicial conduct when a political sword of Damocles continually threatens the judge's source of livelihood. And the Attorney General report summarized that removal of a hearing commissioner during his term should be for cause only and by a trial board independent of the agency. There was a widespread recognition of bias, of unfairness, and the appearance of unfairness of having administrative judges who can be fired at will deciding cases against their bosses. How do you expect any kind of independent fact-finding if the agency itself can fire the administrative law judge if they don't like their tentative findings reached by the ABA? So for 75 years, we've had this kind of authority. And if you go back to what Professor Family said happened in respect to immigration, not just to the agency, but to the judges themselves, we saw under the Trump administration a great deal of pressure exerted by the Attorney General to force specific immigration judges to reach particular issues with respect to deportation, with respect to asylum issues. And that kind of interference can be real, right? And you can undermine this notion of a quasi-independent adjudication within the executive branch of claims against the executive branch itself. Next page, please. So I want to think not just about history, but what might it be about these duties of administrative law judges which would differentiate them from other officers and therefore suggest that the court should pull back and not apply the logic of Sala law and free enterprise fund to the removal authority over ALJs. In other words, to disagree with what Judge Rao of the DC Circuit said this week. So I think the answer in my mind is the president need not be accountable to the public for all actions. John Yoo, who you will hear from momentarily, was in the Justice Department, but that doesn't mean that the president, and he was very influential, but that doesn't mean the president had to remove him at will. Why? Because he was exercising a kind of professional expertise. And I could mention Anthony Fauci, and probably no one has mentioned John Yoo and Anthony Fauci in the same sentence before, but Anthony Fauci, his independence has been prized by many, and he wields power because of his professional expertise, just the way John Yoo did. And I want to take 2 detours of other areas within where the government has recognized a difference between this professional expertise and forward-looking policymaking. Both are important, but only the president, I would suggest, only needs to be accountable under this theory of a unitary executive for forward-looking political, social, and economic policymaking, not the exercise of professional discretion. So what are some examples? Under the Federal Tort Claims Act, Congress waived the immunity of the government from tort suits, but it said there should be an exception when there's discretionary functions involved. What does that mean? Over time, the court had to decide what kind of actions the president, that the government should not have judges second guess. What kind of discretion should be immune from challenge under this waiver of sovereign immunity? And the court decided that it was not professional expertise, architects, lawyers, doctors, but rather it was the idea of forward-looking social and policymaking. Next page, please. And the same thing is true under the Labor Service Management Relations Statute, because there Congress authorized unions among public employees, but professional employees were exempted. And just to read you very quickly, what the Federal Labor Relations Authority, another independent agency, said is that that managerial employees who cannot organize, who are not professional employees, they create, establish, or prescribe general principles, plans, or courses of action for an agency. They bring about or obtain a result as to adoption of general principles. And if you go, and indeed the union of ALJs has been recognized for 20 years because they're professional employees, not because they create policy for the future. So if you go to the next page, you can see when in thinking about the ALJ duties, right, they apply professional judgment to the facts at hand. They don't have the power to make law. They can't change agency power. And they're all subject to review. And they're backward-looking powers. They're not forward-looking powers. So I would suggest that in thinking not only about history, but about thinking about what kind of duties the president must be accountable for. The president doesn't have to be accountable for professional expertise. Yes, ALJs are inferior officers, and yes, professional expertise is important. But the kind of things the voter will link to the president are the kind of forward-looking policies that involve politics, economics, and so forth. And that's not the stuff of which ALJs are made. Thank you.
Wow, you guys are great, right on time. So Professor Richard Sala, you're up.
All right. Thank you, Professor Parenteau. I want to briefly thank Professor Family, Professor Krent, and Professor Yoo for joining the Vermont Law Review Symposium today. I only joined academia in July of 2019, so it's really an honor at my first symposium, and by the time I'm done talking, likely my last symposium, to join such a distinguished panel to discuss the legacy of the Trump administration as it relates to executive power. In full disclosure, when I started considering a topic to discuss, my plan was to find any topic that would allow me to say the president had inherent or implied Article 2 powers. Then I would say, isn't that right, Professor Yoo? And I could yield him the balance of my time, jump in at the 14-minute mark, interrupt him, say a sentence in closing, turn off my camera, and be done flipping my 5-year-old son Reese's Pieces like he was E.T. to keep him from making an unannounced guest appearance at today's symposium. But that wasn't to be. Instead of discussing actions taken by the president pursuant to inherent and implied Article 2 powers, I ended up deciding to discuss actions the president considered taking pursuant to an express authorization by Congress. On June 1st, 2020 at 6:43 p.m., days after peaceable protests across the United States condemning the death of George Floyd while in police custody devolved into chaos, President Trump addressed the nation from the White House Rose Garden. And during that 7-minute statement, President Trump avowed, quote, "If a city or a state refuses to take the actions that are necessary to defend the life and property of their residents, then I will deploy the United States military and quickly solve the problem for them," end quote. At the time, I really thought nothing of this statement. In my mind, there was simply nothing novel about deploying the military on domestic soil. The military has joint publications on defense support of civil authorities. The military has field manuals on civil disturbance operations. We have standing doctrine and tactics, techniques, and procedures for quelling riots and restoring public order. And that's true both in the continental United States and outside the continental United States. And I'll just offer a couple of examples. I'll use the Marine Corps as an example because it's the branch I'm most familiar with. But in the late 19th century, Marines assisted New York police in a series of raids on illegal distilleries. And I apologize for that. In the late 1800s and the early 1900s, the Marine Corps was called upon to guard the federal mail during a string of U.S. mail robberies. Marines helped put down a riot on Alcatraz Island in the 1940s. In 1957, President Eisenhower sent federal troops to Arkansas to desegregate schools, and he did that over the objections of Arkansas Governor Orville Faubus. To be fair to my sister services, that one wasn't the Marines. Marines filled gaps during riots at the beginning of the Civil Rights Movement and again during uprisings resulting from the ongoing United States involvement in Vietnam. In 1962, the Marine Corps assisted in the movement of troops, ensuring that James Meredith could enroll in and attend the University of Mississippi. And in the late 1960s, Marines helped restore order after riots in D.C. Most recently, in 1992, Marines helped restore order in Los Angeles after protests of the acquittal of officers accused of beating Rodney King turned violent. Nevertheless, critics quickly took to newspapers, to magazines, publications, websites, social media to condemn President Trump's ultimatum. And the maelstrom of critiques pointedly questioned the president's judgment, that voiced serious disagreement with the president's response to the ongoing civil unrest, and decried the suggestion of military intervention. But some critics took their disapproval a step further, suggesting that the president's avowal to deploy the United States military to quell civil unrest was more than a severe error in judgment. Some critics seem to suggest that deploying the military in response to the ongoing civil strife was in contravention with the Constitution and the laws of the United States. Which led me to the second reason President Trump's words didn't trigger my spidey sense. The military also has a domestic operational law handbook, which it turns out that I've read. And one of the laws specifically referenced in the domestic operational law handbook is the Insurrection Act. And the language of the Insurrection Act is exceedingly deferential to the determination of the president. That deference is enjoyed by presidents that we like, and it's enjoyed by presidents we don't like. If you're interested in reading the language, you could look at 10 U.S.C. section 251 to 253. I'm going to focus on 252 and 253, but I'll say a brief word about section 251. Section 251 offers a nod to state sovereignty. It thinks about the fundamental constitutional principle of federalism. It functions when the president receives a request from the state government for assistance, but it's important to note that the Insurrection Act simply doesn't require a state to request assistance. If you look at section 252, and I'm going to quote, it states, whenever the president considers that unlawful obstructions, combinations, or assemblages or rebellion against the authority of the United States make it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings, he may call into federal service such of the militia of any state and use such of the armed forces as he considers necessary to enforce those laws or to suppress the rebellion. And section 253 goes further still. It says, the president, by using the militia or the armed forces or both, or by any other means, shall take such measures as he considers necessary to suppress in a state, and this is a little bit different language here, to suppress in a state any insurrection, violence, unlawful combination, or conspiracy. And the president can do this when one of two things is true. The president can do this if he finds that the insurrection, domestic violence, and unlawful combination or conspiracy hinders the execution of the laws of that state and of the United States within that state, such that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law. And then additionally, under this prong, it says, and if the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity. The president can also call forth the militia or the military if he feels that the insurrection, domestic violence, unlawful combination, or conspiracy opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. Once we establish that the president has this authority, I think the question that follows is, what if the president uses this authority in an undesirable way? And that's not to suggest that President Trump was using it in an undesirable way. After all, what President Trump did was articulate a possible response option, which he never opted to engage. The effect that ultimatum had on the response of state officials to the civil unrest will never be known. But I would argue that the president showed restraint in this instance. So back to our question. What is to be done if the president uses this authority in an undesirable way? And I think the answer is not much. The courts are unlikely to provide redress for several reasons. First, there's case law directly on point. Two important cases that consider the Militia Act of 1795, which is a precursor to the Insurrection Act. If we look back historically, on June 19th, 1812, President James Madison declared war on Great Britain. President Madison ordered the militia into federal service for this purpose. Federalists opposed the war. Riots broke out between Federalists and Republicans in major cities across the country. Several states rejected the idea that the president could unilaterally call the militia into service. And so the president's authority to call out state troops was placed squarely before the Supreme Court of the United States in Martin versus Mott. Justice Story wrote for the court in Martin versus Mott and addressed the issue of who was best suited to determine whether circumstances justified calling forth the military. And this is what he said. Justice Story wrote, "If we look at the language of the Act of 1795, every conclusion drawn from the nature of the power is strongly fortified. The words are, whenever the United States shall be invaded or be in imminent danger of invasion, it shall be lawful for the president to call forth such number of the militia as he may judge necessary to repel the invasion." Justice Story went on, he said, he, the president, is necessarily constituted the judge of the existence of the exigency in the first instance, and is bound to act according to his belief of the facts. The law does not provide for an appeal from the judgment of the president, and whenever a statute gives a discretionary power to any person to be exercised by him upon his own opinion of certain facts, it's a sound rule of construction that the statute constitutes him the sole and exclusive judge of the existence of those facts. In 1849, the court would answer a similar question in Luther versus Borden. This time, Chief Justice Roger Taney would announce the court's opinion, referencing Martin versus Mott, and again looking at the language of the Militia Act of 1795. Chief Justice Taney wrote, "By this act, the power of deciding whether the exigency had arisen upon the government of the United States is bound to interfere is given to the president." There are other reasons to believe that the courts are unlikely to interfere, though I don't have time to address them all in depth. I'll just note that the application of Justice Jackson's Youngstown concurrence would almost certainly support President Trump's authority to deploy the military pursuant to the Insurrection Act. For those who might not be familiar with Justice Jackson's three-part framework, it's the accepted framework for evaluating the lawfulness of executive action. This framework notes that a president's authority, when acting pursuant to an authorization from Congress, is at its zenith. Under these circumstances, it personifies the federal sovereignty. There's also the possibility of the political question doctrine. But no matter which of these routes the court chooses to travel, it's unlikely to upset the president's determination under these circumstances. Of course, this doesn't leave the dissatisfied without recourse. In Luther versus Borden, Chief Justice Taney confirmed the identity of the appropriate arbiter of these grievances. He wrote, "Undoubtedly, if the president in exercising this power shall fall into error or invade the rights of the people of the state, it would be in the power of Congress to apply the proper remedy. But the courts must administer the law as they find it." Of course, when impeachment and trial by Senate are unsuccessful, the greatest bulwark against tyranny remains an engaged populace arriving at the ballot box. The possibility of Congress addressing this authority came to fruition just days after President Insurrection Act in the United States Senate, and soon after, Veronica Escobar introduced an amendment to the National Defense Authorization Act for fiscal year 2021, designed to overhaul the Insurrection Act. The suggested modifications were numerous. I won't go through them all. Despite bipartisan public pushback after President Trump's Rose Garden statement, Senator Blumenthal's bill to curtail the president's use of the Insurrection Act never even received a vote in the Senate. Conversely, the House of Representatives approved Congresswoman Escobar's amendment to curtail the president's use of the Insurrection Act in a vote that went 215 to 190. But the passage of the House notwithstanding, after House and Senate negotiators finished reconciliation, the final NDAA for fiscal year 2021 contained the Insurrection Act. All of this is not to concede that the president has some independent authority to call forth the militia, to call forth the military in response to civil unrest. After all, the Militia Act only references the militia. But for the time being, the commander-in-chief need not rely solely on his Article 2 powers. Congress has authorized the president to bring the full weight of the government to bear on any insurrection, domestic violence, unlawful combination, rebellion, or conspiracy, if in the president's judgment he deems it necessary. The legacy of the 45th administration of the United States, at least in this regard and under these circumstances, is one of conformity and restraint. Thank you.
Well done, Richard. And batting cleanup is Professor John Yoo, who comes to us from California, which I think may be the last warm place in the country right now, John. Go ahead.
Thanks, Pat. And I apologize. I've been having some internet difficulties, so I hope that this all works out. It's great to be with you. I wish I was able to be there in Vermont, although given what you just said, maybe for once it's better to be in California. This is one of the few times that we have more electricity than everybody else in the country. But for some reason, our internet's been really been on the fritz this last week, actually. So I apologize for anything that comes up during the presentation. It's really great also to be here with each of the panelists. I'm actually from the Philadelphia area, and I grew up in Philly, and a lot of my classmates in high school went to Widener and did the local government concentration. It's great to see Jill. And Harold, of course, is one of the longest, one of the scholars who writes in presidential powers that I've followed the longest. I remember reading articles by him about the executive branch when I first started as a law professor long ago. So it's great. And he's got this great book he put out in the mid-2000s about the presidency that I enjoyed. And then Richard's really the reason I'm here, because the last time I was at the Vermont Law Review Symposium, Richard probably doesn't want to remember this, but he was a student and he was in charge of this symposium. And he asked me to write a piece about war powers, which I did and published in the Law Review about Lincoln. And it was one of my favorite pieces. And so when he asked me to come back again, it was a real pleasure. And he asked me to write about war powers again, which I've done. I hope it turns out well in the Journal Symposium. And I'm just going to summarize some of the points here and really look forward to the discussion. And the reason why is because I think Trump, when it came to war powers, sort of reversed the kind of questions we commonly ask ourselves. The standard debate on war powers, you may all know, is who has the constitutional power to start a war. So you have what I think of as probably the majority view among scholars, a traditional view amongst many lawyers, is that Congress has the power to declare war in Article 1, Section 8. So it has to go first and decide whether to start hostilities. And then once that happens, the president, as commander-in-chief, he or she then accesses that constitutional authority to wage the war. The minority view, of which I'm part, thinks that practice, which has not respected this idea of Congress going first and making decision on war, has more to say in terms of the constitutional structure that, to me, at any rate, the Constitution creates a presidency and a Congress with what could be complementary powers to wage war, but also could be powers that come into conflict meant to disrupt and undermine each other. And I think the story of war powers, at least since World War II, has been this oscillation between cooperation and conflict between the two branches for primacy over war. But what President Trump, I think, asks us to consider, and this is part of a larger thing I'm working on about what I call the president's power of reversal, which I think is probably the president's one of his most important, but not so much discussed powers, was, can the president undo the past decisions of presidents and Congresses in war? So President Trump, he did use the war powers controversially twice. He, if you may remember, bombed Syria after Syria had used chemical weapons. And then he also increased U.S. cooperation with Saudi Arabia in its efforts to intervene in the civil war in Yemen. In both cases, people criticized President Trump, much the way they criticized President Obama or President Bush or President Clinton or President Bush or President Reagan, you go all the way back at least to President Truman, for waging wars without congressional approval, because neither the Syria nor Yemen interventions had received any kind of specific authorization from Congress. And I don't think that those two episodes sort of introduce or change the war powers debate that we've been having ever since the Vietnam War or before. But I think what's interesting, which Trump raised, which is a new question for war power scholars and scholars of the presidency, is the power of the president to undo war or reverse war. So President Trump more famously wanted to withdraw the United States from deployments all around the world. He threatened to remove troops from Japan, from Korea, from Germany, but he actually went ahead and did withdraw troops from Syria. He dramatically drew down troops elsewhere in the Middle East, often in opposition to what Congress wanted. Congress wanted troops to stay in the long-term deployments in Germany, Japan, and Korea. And Congress, it appears, wanted troops to stay in Afghanistan, where Trump almost decided to pull troops down to zero, wanted troops to stay in Iraq and Syria. In fact, Trump's decision to withdraw from Syria and his threat to reach a peace deal with the Taliban led to the resignations of his Secretary of Defense, Jim Mattis, and John Bolton, the National Security Advisor. So the question I pose in the article I've submitted to the journal is how do war powers scholars reconcile their views about starting war with their powers, with the president's powers to end war? If you take the view, which I described as the majority view, which is rooted in the Declare War Clause, does the Declare War Clause basically mirror in war the conventional separation of powers and domestic policy, where the Congress passes a law and then the president under the Take Care Clause has to implement it or execute it? That's often the model, I think, that people who are in favor of Congress having the upper hand through the Declare War Clause have in mind for foreign affairs too. But if that's true, does that mean that a president who's waging war under the Commander-in-Chief Clause, subject to Congress's approval of that war, can't effectively end the war? Does a president have to keep troops in Afghanistan, Syria, and Iraq because Congress wants them there, even if the president thinks that it no longer advances America's national interest, or even if the president thinks it makes for bad strategy or tactics? Does the view, again, the majority view about Congress being in charge of war policy mean that Congress need not use its funding powers? That's actually the clause I think is the most important one, but I think in the war powers debate gets less attention. But can Congress just simply pass a law through the Declare War Clause requiring troops to remain in places where the president wants to remove them? To me, it seems that the minority view, the one that I'm a part of, makes the most sense of that. That it seems to me a president constitutionally, as commander-in-chief, has the authority to remove troops, effectively to end a war, even if Congress wants to keep it going. That Congress has the power to appropriate money, to create and raise armies and navies, to keep them funded. But I think, and this is where it's very different than domestic policy, the president still has the power to stop it. The president doesn't have to carry forward and execute a war that he or she thinks is bad policy. Congress can declare war all at once. Congress can create a military all at once. But what Congress can't do is force a president under the Commander-in-Chief Clause to wage that war, to make certain strategic and tactical decisions against his or her better judgment. And I think that, to me, is a new part of the Declare War Clause versus Commander-in-Chief Clause argument, because I think if you agree with me, then it actually feeds back into the original debate, in that we should understand the Commander-in-Chief Clause to have much more scope and discretion than a lot of legal scholars think it should. Just just a few minutes. I think there's just a few minutes remaining. Just sort of situate where I think this leads in terms of a broader, sort of interesting aspect of presidential power. As I said, you could think of this as part of this larger question of the undoing of past presidencies or past presidential acts. And so we're used to the idea that when you want to undo something in the law, you usually do the exact same thing to reverse the previous act. So you might notice the Constitution has very little in it about undoing anything. The Constitution doesn't tell you how do you repeal a law, but we just assume to repeal a law, Congress passes a new law. Doesn't say anything about how do you overrule an old Supreme Court decision. Well, we just assume you decide a new Supreme Court decision that overrules the old decision. Notice that in a lot of areas, and Harold in particular has written about this, but notice in a lot of areas that is not true of the executive power. In fact, often in the executive power, it is easier to undo the action of a past president than it was for he or she to have done it in the first place. So we've had a lot of fighting. Harold mentioned the removal power. Think about it. We generally accept, maybe not with ALJs, but we generally accept with cabinet officers, for example, that to get someone appointed, generally, because Congress requires this when it passes, creates the office, president nominates, Senate gives advice and consent to the officer, and then the appointment is completed. But notice, to get rid of the cabinet officer, all you have to do is for the president to fire them. Fire him or doesn't need the Senate's permission. Easier to undo the appointment than it was to make it in the first place. Think about treaties. One of the hardest things to do in our constitutional system. It's just as hard as, at least at the federal level, as what's required to get a constitutional amendment to the states. President negotiates a treaty, signs it, then submits it to the Senate for advice and consent by 2/3. Notice, though, to undo the treaty, the president can act alone to terminate it. Again, presidents can find it easier to undo the acts of past presidents than it is to engage them in the first place. And so I think taking that theme and applying it to war powers, it's interesting. It seems to me that consistent with that, presidents should also have the ability to end wars, no matter whether you think presidents need congressional consent or not. But even if you think they do, maybe people on that side of the debate should look more favorably on the ability of a president to exercise a broad commander-in-chief power to effectively end a war just by ceasing to continue the hostilities. The interesting thing, one last interesting point, and I think just to summarize, I think how this actually intersects with the other issues we've talked about on the panel is that, when we look at Trump and then from Obama to Trump and then Trump to Biden, each president used this power of reversal to try to undo the decisions of their rivals in each of these areas that we've all discussed. And one broader question is, why do we want to make it easier for executives to undo the decisions of past executives than it was to make it, to create it in the first place? Is there a constitutional bias towards inaction and repeal, and a constitutional bias against new actions? Is it, and then I think this is one of the more important checks on presidential power that we don't focus on. We think of checks as coming from proposals for statutes or changes in constitutional law, as in the Supreme Court, changes in administrative regulations. But maybe one of the most important checks is just the political process creates the possibility of the election of a person who will undo all the past president's acts, and that will by itself cause current occupants of the office to restrain themselves. So thanks very much for inviting me to come back to Vermont, albeit virtually, and look forward to comments and discussion and questions. Thanks very much.
Great job. John. Great job, panel. I think this has been a terrific, focused panel with very efficient, very sharp presentations and all on time. How about that? While we're waiting for some Q&A from the audience, why don't I give the panelists an opportunity, if you want it, to ask one another any questions that might occur to you. And if you don't have any questions, I'll throw a toss-up out there for you. Anybody want to pose a question to one of the panelists?
I'd be happy to ask a question to John Yoo, which I think your point about reversals is very intriguing and opens up a lot of lines of inquiry. And I obviously have not spent that much time considering it, but I wonder how you reconcile mainstream administrative law, which suggests that reversals are just as hard as creating a rule in the first place, with the idea of presidential reversals in these other areas that you've talked about, treaties, removal authority, maybe through executive orders, et cetera. Is it because of the presence of the apex, and so that therefore we want to have more flexibility at the apex, whereas down more in the trenches, whether it's in immigration or in housing, we demand much more slow, ponderous, deliberative action? That's my question.
Now, Harry, that's a great question. I'm curious to hear what you think of this reading because I think this is where I think the DACA case from the summer upended things. But I'm curious to hear what you think too. So in the DACA case, you remember President Obama issued a kind of enforcement memo, right? It wasn't even an executive order per se, but it was a sort of memo about enforcement authorities in the context of immigration. And so, as we know, the executive branch decided to essentially come close to what the DACA bill would have done through prioritization of removal and reducing removal priorities for people who fell into the Dreamers class. The thing I thought that was strange about the DACA case, and it is, you're right, it is kind of contrary to what I was arguing, but that's why I thought it was so surprising, was that the court essentially makes it harder to undo that presidential decision than it is to do it in the first place. Right? It's sort of the reverse. So that's one puzzle, was that why should the undoing of the DACA program be subject to the Administrative Procedure Act when its creation was not subject to the Administrative Procedure Act? I totally agree with your broader point, which is when it comes to the use of administrative discretion, especially the kind that you were talking about in your paper with ALJs, for example. The Congress has tried to, I think I agree with you, through the Administrative Procedure Act, to try at least to equalize repeal and creation. So they kind of try to counteract the president's ability to repeal things easily. They don't make it harder. Until the DACA case, it was usually even. It was more like Congress or the courts having to do the same thing formally. And so the reason I think it's interesting is because it has something, to me, maybe this is totally off base, but it seems to me to have a lot to do with the delegation doctrine. That this is part of the right? Because the president in none of these areas is supposedly exercising presidential power. He or she is just using delegated legislative power. And so Congress is using the Administrative Procedure Act to keep strings attached to that power because they don't want the president to get too much discretion from the grant of authority, even though we know the various reasons Congress likes to do it politically. I guess what I would say is just as it closes, just that the Administrative Procedure seems to me to do no serious harm to this broader idea of presidents being able to reverse past presidents because there's not an air executive authority. But I think that the court's decision over the summer and the DACA case rang an off note. And I just throw this to other panelists or students, that how would people have felt if Trump had managed to put into effect some of his own immigration policies by direct executive order or through various non-formal memos? And then the court were to say, well, it's going to take 2 or 3 years for President Biden to undo what President Trump did in immigration because of our DACA opinion from last summer.
So, Professor Family, do you have something to say to John?
Just to sort of add on, I mean, I guess I have a little bit of a different take on the the DACA opinion, in that my understanding was that the Supreme Court found the Trump administration's actions eliminating DACA were arbitrary and capricious, which to me is a whole other kettle of fish. So the Trump administration used another guidance document to try to get rid of the DACA program. And in administrative law, you can do that. You can use a guidance document to eliminate a prior guidance document. But as always in administrative law, your actions can't be arbitrary and capricious. And so I just think I have a little bit of a different read. I don't know that the Supreme Court necessarily made it more difficult. To me, they were just applying this more general administrative law construct that whatever an agency does always has to not be arbitrary and capricious.
Yeah, so my only point was that personally, I don't really care for the Trump administration's policy here, but why is President Trump's decision, right? And you're quite correct in the way the court held it, but why is President Trump's decision about the allocation of prosecutorial resources subject to the arbitrary and capricious standard of the Administrative Procedure Act when President Obama, when he created the DACA program, which as a matter of policy, I think is a great idea, but I thought Congress ought to do it. But when President Obama did it, he did not have to meet any arbitrary and capricious standard because he was acting in the area of prosecutorial discretion. And under it's a Heckler versus Cheney, that decision is presumptively unreviewable by the courts.
Joe?
So I guess, I think that the DACA program would have been susceptible to arguments that it was being implemented in an arbitrary and capricious way. And I also think if you go back to the rule of law principles from my presentation, you could argue, and I would argue, that DACA actually, while it was created through a guidance document, that it actually served rule of law principles because it took a system of prosecutorial discretion that was mostly shadowy, had no application procedure. No immigration attorneys were always completely sure how you would even ask for prosecutorial discretion, let alone what the decision-making factors would be in deciding whether or not to issue someone prosecutorial discretion. And it brought that whole process into the open. It was much more transparent. So in some ways, I think that not all guidance documents are equal, I guess is the argument that I would make. And I think that some of the guidance-based document actions under the Trump administration did not serve rule of law principles, while as, it's possible that others in other administrations did. And I also think too, it's, I don't want to make this seem like it's completely partisan, because it's not. If you go back to even Republican administrations like the Bush administration, the guidance documents were different. Even the immigration lawyers that I talked to said, even under Republican administrations, there was still a sense that they genuinely wanted the system to work, and they understood that their obligation under the statute. And of course, there were hiccups and bad training here and there. But under the Trump administration, there was this foreboding sense of, wow, he just wants to run this whole thing into the ground. And that was very different than what had happened even under prior Republican administrations.
Shall we throw another log on the fire? Richard, do you have a question for Joe?
That was just, I guess it's a short question. Just, how do we hold the president accountable for the actions of agencies that are supposed to be under the president's purview? If we're looking for a system where the agencies are resisting the direction of executive control.
Yeah, and I think that probably gets to a little bit of, what's your idea of the executive branch as a whole, and how committed are you to the unitary executive theory, and also to me, I agree with Harold's characterization that, agencies do different things. At times they're acting in a more political way. At times they're acting in a more sort of expertise policy role. And I think my general point is, though, that if an agency is resisting White House centralized control that goes against rule of law principles, I'm good with that. And I do think that there have to be some checks and balances within the executive branch, especially when we fold in the idea that judicial review isn't completely effective. I think we have to do what we can to protect against this gap in unchecked executive power that I've identified.
And Hal, did you want to jump in on some point here?
Just to take us back a little bit to the DACA case, I want to give John some encouragement that I don't think the DACA case cuts against your theory that much. Because what the court seemed to be saying was, if President Trump had said, President Obama, in his discretion, articulated this policy of forbearance, I, in my prosecutorial discretion, have taken away the forbearance, I think that would have been fine. And I think the court would have accepted that. I think the court was only enmeshed in the DACA case because President Trump refused to do that and said that the forbearance was illegal, and then came up with a different kind of explanation that was half-cocked in order to justify repealing the policy. So I don't think I think you should continue on. And I think your basic point that maybe reversals are different depending upon the heads or the constitutional powers is also, at least on the, without thinking about it further, very productive, right? That maybe reversing in terms of delegation through the Commerce Clause is harder than reversing through the treaty, war powers, removal, different founts of constitutional authority. So maybe thinking about why those founts of authority might lead to different kind of reversals in different ways might be very helpful down the road for you. So just a suggestion.
And John,
well, first, I agree with Harold's read. I'm not, I don't know though. This is just predictive, but gosh, I think that if the Roberts Court that last summer had, President Trump had actually given the more minimalist explanation. Suppose he had done what Harold suggested, just said, I'm just restoring enforcement priorities to what they were before DACA, and didn't give any explanation. I would have thought before the DACA case that would have been perfectly fine. After that DACA case, I'm not so sure, frankly. It seems to me the court would have struck that down too. It's strange because if you're right, and I agree with you, that would be the proper way to read it. That almost punishes the executive branch for giving too many reasons for why it's undoing something. The easier thing for a president to do then is just reverse what the past president did and don't give any explanation. But that tied also to this question I had about this rule of law principle that Jill was raising is, the rule of law, this means different things to different people because it's not in the constitutional text. And so I quite accept that you can be an executive branch and say, if you're an ALJ or a member of ICE and you want to say, I don't think the president's order on enforcement about the DACA immigration policy meets my view on the rule of law standards, and you have some ability to resist it, and ultimately the president can remove you if you're, I think, in the executive branch at least. But it's hard to point to a constitutional text that gives you that right, I think. Traditionally, if this were a case about individual liberties, you would say, well, the rule of law principles might come from the due process clause. But I don't think the courts are willing to use a due process clause when it comes to regularizing executive action vis-a-vis Congress. And that also goes, I think, to Harold's point. Response was, where does Congress kind of get the ability to use things like the Administrative Procedure Act or other things to try to tamp down on presidential discretion to undo past acts, or to make it. I was thinking, suppose Congress did it, made it even worse. Suppose Congress, through the Administrative Procedure Act, just made it harder to undo past regulations instead of just making it just as easy. Could Congress do that? Could Congress kind of make administrative regulation a sort of one-way ratchet? That's what I kind of fear the DACA case was doing.
Jill, do you have a question for Hal?
Yes, Hal, I really enjoyed your presentation. I teach administrative law as well as immigration law, and so that was a good review for me because I'm just in a couple of weeks about to get to that part of the class. So thank you. And my question for you is, as I was listening to your argument, which I found very persuasive, but I started thinking, are you essentially making an argument that you disagree with the conclusion that ALJs are officers? So is your argument sort of a way to get around the Supreme Court's decision that they are inferior officers?
I guess the question that I have is it so clear that presidents have to have plenary removal authority over all officers? Why isn't it up for Congress to decide at its discretion which officers to shield from the president's removal authority, as long as the president retains the removal authority? And my suggestion is that there are good reasons in terms of thinking about when you don't have to trace the line of accountability to the president, then the Congress should say those individuals can be protected, not totally, but just from the at-will removal authority. That's just the way I would dice it. And so in other words, there's no congruence between saying somebody's an officer and saying you have to have plenary removal authority. After all, the Constitution is silent as to the removal authority. They just basically either assumed it would follow the appointment power or forgot about it. One of the two, who knows? But there's nothing to say that the president has to have this very tight connection with all inferior officers in the United States.
So we do have a question from the audience. It's for John, and it reads, how does your view of the president's Article 1 power, including the power to undo, apply, or does it, to statutory authority? And if I can be permitted, maybe the way to sharpen this is, I think you said, John, if Congress were to declare war and appropriate funds to raise an army to prosecute it, that the president could refuse to do that? Did we hear you right on that? And how would that square with the take care clause?
Yeah, thanks for the question, and thanks for your amendment, Pat. I do think, and this was part of my arguments, that because it's foreign affairs, the president's commander-in-chief authority is actually much more than the domestic equivalent, which we think of as being the executive power or the take care clause. In that it seems to me a president in foreign affairs can effectively decide not to wage war. Harold in his presentation looked at some of the early decisions of the founders. I think one good example is the quasi-war with France, which Congress really wanted to wage war against France in the late 1790s. And it was really President Adams who didn't want to, and he was quite sort of lax in pursuing it, and then sought to end it relatively quickly. In domestic affairs, we used to think presidents couldn't do that, right? That Congress enacted a law, provided money for its enforcement, created an agency. Well, then the president would have to carry it out. This DACA case is the thing that gives me some pause there, though, because the DACA case, or at least the DACA program, sort to make domestic affairs look more like foreign affairs. So can a president now say, okay, here's this immigration statute. Congress has provided money for its enforcement, has created an agency, but I am going to prioritize enforcement to focus almost all the enforcement authorities on a small class of those in the potential category of cases because of my take care discretion. to me, that's coming a lot closer to the kind of discretion I'm taking, I'm attributing to the commander-in-chief in wartime. And then, so just to focus on the written question, I wouldn't call it a president's Article 1 power. He doesn't have an Article 1 power, like many state governors have to do line item vetoes and so on. But the DACA case seems to open up to me this idea that can a president, can he or she press their prosecutorial discretion so far as to essentially frustrate what Congress wants to do through statute just by saying, well, I'm not going to enforce it. In fact, I was just thinking this in the news because, there's all this debate now in the stimulus bill about student loans. Could the president just say, and there's a statutory argument about why the Department of Education might be able to waive the collection of federal student loans. I'm sure this is going to be great for students will support this expansion of presidential power, by the way. But could a president just say, we're in a pandemic, the economy's doing terribly, our students are getting clobbered by debt. I'm just going to order federal officials not to collect any more student loan debt, just out of matter of prosecutorial discretion. Doesn't that effectively frustrate Congress and its Article 1 powers?
It's a good question. There was a follow-up here, John, for you, and this is testing your fealty to originalist jurisprudence, I think is the way I'd put this, okay? So how does your interpretation of the declare war and commander-in-chief clauses relate to the original understanding of those constitutional provisions?
Yeah, I'm a what did Justice Scalia say? Faint-hearted originalist, in that I tend to be an originalist just because all the other theories are worse. But so here's my argument about originals. I don't know why people just don't think this is a good argument, but this is where I originally got the idea. And to the students out there, I got the idea just sitting in my office, my first year as a law professor, and I just read the Constitution and tried to find every place it mentioned war, and try to figure out, so as to shed some light. It's kind of like the argument we just had about impeachment. Everybody, I thought it was great. Everyone arguing about president, vice president, officers, and nice civil officers, who can be impeached. Does impeachment power apply to people outside that list? That was all great. I'm glad people argued that way. So the clause that to me seemed to really signal, because of originalist, original priors, that this more flexible view of war powers makes more sense than the declare war clause view, is Article 1, Section 10. And Article 1, Section 10 has a clause at the end, which people rarely look at. And it says, no state shall, without the consent of Congress, and then it says, engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. So to me, that is what people think the declare war clause means, right? That people think, oh, the declare war clause means that no president can, without the consent of Congress, engage in war. And people who support the declare war clause view also read in these exceptions, because the declare war clause doesn't say, well, it's waived if there's an attack on the U.S., but everyone says, well, of course, as a matter of reason, that has to be the case. Or you don't need Congress's permission for anticipatory self-defense. But look, Article 1, Section 10 has those exact exceptions in them. So the reason I start out that way in the originalist vein with my view is, wow, if the founders had wanted to create the declare war clause system that many faculty are in favor of, they only needed to change one word in that provision. All they had to say was no president shall, without the consent of Congress, engage in war, and so on and so forth. So to me, if the founders were quite capable of writing a very detailed, delicate provision that actually encompasses all the concerns that modern scholars have about declaring war, well, they could have done it, but they did not. Instead, they wrote these weird commander-in-chief here, declare war clause here. They don't define either of those terms. So to me, it suggested a very different approach to war powers than what a lot of scholars were thinking sort of in the post-Vietnam period.
Thanks for that explanation, John. And that's all right. So because the student debt issue weighs heavily on the minds of our students, I'm going back to Hal because he's got an answer to the question, and I think he's going to announce that Biden is going to waive all student debt. Is that right, Hal?
Can you get home mortgages in there too?
Probably the difference, though, of course, is if it's student debt is owned by the government or owned by private parties, but we won't go there. What's interesting about the question of student debt is presidents, and here I guess I'm changing my views. I'm becoming more of a Unitarian. There's a long tradition in our country that prosecutorial decisions are not second-guessed except at the ballot box. And so in the United States, unlike in some foreign countries, you can't second-guess the decision whether to prosecute someone or not. And we'll see what happens with President Trump in Georgia in terms of the criminal investigation. Can't force him to go against a murderer, can't force a prosecutor to go against somebody who's cheating on student loans. So I think that tradition plays out with respect to the chief prosecutor as well, is we can't force the president to take steps in terms of enforcement that the president through the agencies don't want to take. At some point, there's such an abdication of enforcement, and one time the Supreme Court said this, it would be an extreme case for a court to interfere in this exercise of discretion. And I think that's true with impoundment of funds as well. Presidents don't spend all the money that Congress appropriates because of this similar type of discretion. So our traditions really, I think, privilege to a large extent the president's decision not to enforce any kind of student loan debt, unless, of course, private parties are at issue. Because that's where I think the difference between the DACA is there were no private parties directly affected, maybe indirectly affected. But here, if there were banks that were expecting money due, they would be able to sue and then challenge, and then we would see how the courts would resolve it.
Well, panel, we're approaching the end of our time. I'll throw one last question out at you, and that is, there's a thought or a sense, I think, that maybe power has been accreting to the president over the last, several years. I don't know whether you agree with that or not. I'd be interested to see what you think about that. But if it were true that the balance of power here between the president and the Congress is a bit out of whack, what do you think should be done about that? Should Congress begin to try to retrieve some of its authority by enacting laws, or do we really think that it all comes down to the courts reviewing this? Anybody?
I'll just do a quick answer. I mean, I think Congress has sat back and done very little. Congress needs to assert its prerogatives. At some point, it'll intrude into the Commander-in-Chief clause, but it's got a long way to go before it gets there. And it, for instance, it didn't have to delegate to the president the opportunity to say anything's an emergency, and therefore I can reappropriate funds to the border wall just because I've made up a new emergency, right? If Congress were more clear and more stratified, that would limit presidential power.
Jill?
Yeah, I agree with that. I think that Congress does need to do more. And, I've also written about how Congress needs to enact clear, perhaps less expansive delegations to the executive branch and immigration law as well. So I think we've all really been missing Congress, and I wish that they would jump back into the fray.
Richard, should Congress start clawing back some authority here?
No, I think this is. I think the system is working exactly as it's designed. I think the framers knew there would be push and pull between the legislative branch and the executive branch. The Congress is certainly capable of imposing itself if it so desired. It just turns out, it seems that they're more happy to let the executive take the fall for very difficult decisions. But it doesn't strike me as against the constitutional design. It's functioning with the branches pushing and pulling against each other, and sometimes one branch coming out on top and sometimes the other.
John, last word?
I don't think that the Congress is going to change the way things are. Let me just put my practical hat as a former Hill staffer, and there really isn't much political incentive for Congress to sort of take back discretionary power, whether we like it or not as a constitutional matter. Congressmen and congresswomen like it the way it is. You know, they delegate over to the executive branch all the hard decisions about which people get upset. And then they basically exercise power to attack and criticize the agencies and support their constituents, which gets them reelected. But no one's going to get reelected consistently on the grounds of please make all the hard decisions, come back to Congress. And this is true, I think, from area to area, foreign affairs certainly, but also the environment, of course, and immigration now, I think. And I don't see the political incentives changing enough that will cause Congress to, want to exercise its, core. The Constitution puts Congress at the core and assumes it's going to be the primary policymaker, but Congress doesn't want to.
Yeah. Well said, everyone. I want to congratulate you all on terrific presentations and a really good discussion. Thanks for all of your time and scholarship and thought that went into this. I think it's been extremely valuable, and I'm sure the students in the audience got a lot out of it. So thank you very much. I'll turn it back to the host. Be safe out there.